Thank you. Mr. Chairman, Madam Vice Chair, members of the committee, thank you for the opportunity to present before you today. My name is James Chason. I'm a principal in law firm of Chason, Rosner, Leary, and Marshall, and my practice and the practice of my colleagues has been principally involved over the years in representing healthcare providers in claims alleging medical negligence. I would like to address some of the practical aspects of the claim by some that there's a lack of clarity in the coverage of the definition of healthcare providers in the statute. As has already been indicated, when the statute became law in 1976, the year I began to do this, there was a list of healthcare providers, and what has changed is that there are now a whole class of healthcare providers, people we would plainly consider healthcare providers. But as to them, we see in litigation the argument that they are not healthcare providers under the statute and therefore do not receive the benefit of the cap which is applicable in health claims cases. Frankly, I never had a case until recent years involving a physician's assistant, and now we see physician's assistants all the time because they are so much a part of the healthcare team, but the statute has not been updated. What are the practical effects of the fact that the statute has not been updated? The loophole, if you will, is being exploited in order to attempt yet again to avoid the applicable malpractice caps, to drive the costs of these cases upward, and results in clear inequities with regard to practitioners who are doing exactly the same thing. I have recently been involved in a matter of representing a hospital in which licensed practitioners who were not specifically listed in 3-2A01F were named as defendants. Specifically, they were 2 pharmacists and a physician's assistant. The avowed purpose, according to counsel, who named them, was to avoid the malpractice cap statute and have those healthcare providers, those practitioners, fall under the non-healthcare limitation. This was used in an effort to affect the starting and ending points for settlement negotiations. In more personal terms, real people who likely would not have been sued but for this lack of clarity were brought into the case, and the result is that they will be really, frankly, forever marked with having to say, yes, I have been sued, even though it was unnecessary, and they will have to disclose that for licensing and insurance purposes. This was all unnecessary, as they were employees of the hospital, which was vicariously liable for them. And here's the inequity. It is clear that the hospital would be subject to the lower malpractice cap, and yet the argument is that these individuals, who were by any common sense definition of healthcare providers, the argument was that they would not be subject to the same limitation. Same attorneys apparently came upon this argument in a case in Frederick County. There, during the pendency of the case, there was a motion to amend the ad damnum clause. Apparently they hadn't put in a large enough ad damnum clause. And the argument was that the malpractice cap did not apply to these non-listed individuals. I'm advised of another case, not that I was involved in, but resulting in a 3-fold overdose of a drug actually prescribed by a physician. The upshot was that a pharmacist and a physician's assistant were sued, and again the argument was made, well, the cap doesn't apply to them. In part as a result of that argument, that those claims were not capped at the same level as the physician, a disproportionate portion of the settlement was paid on their behalf. The case did settle. In the community setting, we have physician's assistants who work with physicians under delegation agreements. And this is not an actual example, but it is obviously one that's going to arise if it hasn't already. Imagine a physician with a physician's assistant in her or his office. The physician is ultimately responsible for the PA's actions, but 2 different caps would apply. Likely the physician would be dismissed and the case allowed to proceed against the physician's assistant, with the argument that the lower cap did not apply. The economic difference is striking. If you compare the applicable cap for health claims case with that for non-health claims cases, there is a very, very dramatic difference. As the chart that I looked at yesterday The physician's cap on non-economic damages for a death case with a personal injury action and a wrongful death case with multiple claims would be $925,000. If this loophole were successfully exploited, the applicable cap would be $2 million on that case. And this is a result clearly never contemplated by the legislature. There is no question that if physician's assistance had existed when the health claims statute was passed, that category of healthcare provider would have been listed. House Bill 395 solves these inequities and returns things to their intended balance. For all of these foregoing reasons, I urge you to give House Bill 395 a favorable report, and I'm pleased to respond to any questions should you have.